what would happen? Okay, so I think by now we know what are some of the consequences. Whether the plaintiff or defendant. Let's look at the plaintiff first. We said that even though if the plaintiff has won, but if it is, sorry, is it Ron or Sam or what's your name again? Sorry. This is from your course manual, okay? So, and the others are mostly in your handout. So what are the consequences that we discussed? Well, if let's say it's a quantum of 4 million, the plaintiff will still get the judgment award, but what happened to cost? The plaintiff has won, but will he get his cost? Well, time for timeline. Remember, it's a window, so let's say the window was open from when we talk about cost implications, be sure about the timeline. When we have cost implications, the cost implications doesn't happen between the REIT and the SP. Why do we have a window in the SP? Because there's a 28 days, right? And we normally say the cost implications will start from the last day the offer or SO or SP could have been accepted, the 28th day, right? It's like the 11th hour, right? So from here to here is what we're talking about. The relevant period for the implications of the SO or SP. Right? Last day it could have been accepted. This is when it's made, SO or SP. Open for 28 days. The last day the SO or SP could have been accepted. Whether it's SO or SP, doesn't matter. Okay, the cost implications takes place from here until here. But of course, what about post? Okay, what about interest on cost and things like that? It can still happen beyond, right? But this is what we're relevant, the cost counting. Or if we talk about indemnity cost, which cost? Not from here to here, because everybody is innocent, right? No offer has been made. No SP or SO has been made. From here to here, nothing happened, just as is normal. Okay, so if the plaintiff won, this cost from here to here is still going to be paid by the defendant. Any implications only takes place is about the cost from here to here. Okay, about the indemnity basis, about enhanced prejudgment interest. Okay, so that's what we're talking about. So whenever we ask you about cost, but it's okay. If you can remember how we describe it in the course manual, that's good enough for exams. Okay, but for your practical knowledge, this is what we're talking about. So plaintiff has failed to beat the defendant's sanction offer or sanction payment, then it would be cost on indemnity basis from here to here. Enhanced prejudgment interest rate not exceeding 10% above the 8% interest rate, judgment rate. Okay, judgment rate is 8%. The court is entitled to increase as much as up to 10% above that 8. Right, so maximum is 18% in total. What else? Cost on plaintiff. Okay, so here, plaintiff actually is disallowed cost. He has to pay the defendant's costs on an indemnity basis, again from this period to this period. Because think about it, the cost is wasted because the case could have been ended much earlier from the here. Okay, that's why apart from not being paid his costs, he actually had to pay the other side's costs, right? Which is the reverse of not what normally happens. Okay, in question 3, if the defendant fails to beat the plaintiff's sanctioned offer, then again, normally he would have needed to pay costs here to here anyway. From here, last day, from here, offer could have been accepted until trial, indemnity basis, the plaintiff's costs on indemnity basis, enhanced pre-judgment interest, okay, and enhanced interest rate on judgment award, okay, because the plaintiff gets judgment award. Okay. Coda Bank letter offer. Now I'm going to answer the question after I show you the template, but I don't know where to find the HDMI. Let me try to sort it out. Trying to find HDMI. There are too many of them. There's like 3 here. So let me just close this last page of it. So this is the complicated WP letter I told you about. Okay. So you thought that, yes, it's simple, we just talk about the payment terms, about the amount. Now this is about a piece of land that the occupier, a piece of government land that the occupier has occupied without justification and made some changes. So actually, the occupier is now asked or being demanded to use proper professionals to reinstate the piece of land, not only to deliver the vacant possession to the government, but actually to reinstate a lot of things because it actually is a slope. So it ended up to be a very, very expensive exercise. Okay, but it can get very technical. Okay, proprietary right, we deliver that. This is the defendant's offer to the, so it's without prejudice as to cost, and this is all the identifying the land and the encroached area, demolish the existing structure on the piece of government land, reinstate the parts to the original condition to the satisfaction of the government. To also it actually have alternate proposals. So because each has its merits, so it got very complicated. And while one of the reasons it got to be such an expensive exercise is because it's on a slope, and to do the reinstatement works actually involves a lot of precautions and safety measures while doing those reinstatement work. So it got to be very expensive. Now I might as well use my USB to, I think it's this one. Comes into effect after the last day, the 24 hours of last day, so 29th day is when it ends the
So is it the 20th day for that 20 hours? Is that not the last day?
No pictures, please. Okay, so this is a sample of a Tomlin order. A Tomlin order. Okay, so on this occasion, this is from the Lands Tribunal. Okay, it's a consolidated case, so there are actually two case numbers here. Okay, I've just redacted the party's name just now. Okay, so normally when you have an order, you see who is by and the date upon whose application, which judge, or this is from Lands Tribunal, so they call it officer, presiding officer. And whether there was counsel or solicitor representing the parties. And this is, Tomlin order is typically by consent. So what it says is that by consent, it's ordered that all further proceedings in this action be stayed upon the terms of settlement agreed between the parties set out in the schedule. And that's what I mean, like an appendix. Except for the purpose of enforcing the said terms with liberty to apply for the said purpose without the need to start a new claim and or commence a new set of proceedings. Now, what effect does it have is that, okay, on the schedule there are the terms that the parties have to comply with. See, the proceedings, this action will be stayed, right, paused, frozen, when the terms have been complied with. Except, and meaning, unless somebody doesn't comply with the terms in the schedule and we need to reopen, otherwise the action will be stayed. Okay, with liberty to apply is with any auxiliary reasons to the order, you can go back to the court and make applications. Okay, that's what is meant by liberty to apply, for the set purpose of enforcing the terms on the schedule, those terms on the schedule, without the need to start a new action. Okay, date of the order, and this is the schedule. This is a landlord tenancy case. The tenant has typically failed to pay rent, not vacate from the premises. So, well, some of the numbers are not right. Okay, so this continues the claim. The applicant, meaning the plaintiff, right? In Lands Tribunal, we call it applicant and respondent, rather than plaintiff and defendant. Okay, so the plaintiff would discontinue his action, the claims in his action number, whatever, no order as to cost. So the parties agree that which party will bear their own cost. The respondent, the defendant basically, makes the following undertakings: that they will pay the total sum of this much. There would be the deduction from the original deposit, and the schedule, how they will pay by installments. This is, I think, a few months only, so about 3 months. Okay, and this actually is the two consolidated actions. So there are two tables, and the total amount is like $500,000. Okay, but this is how a Tomlin order would look like. We don't need to scroll to the very bottom, but this is just to show you the effect of it is to stay the proceedings pending the carrying out of the terms on the schedule. I can't remember who was asking me about this, right? But this is what a Tomlin order looks like, or the effect of it anyway. So only stayed, not dismissed or not discontinued, right? It's only upon the fulfillment of the terms. Discontinues its claims in the action, right? When we're complying with the rules. Now, when you go further in depth and when you go into practice, discontinue and withdrawal is actually slightly different. Okay, but I don't think we need to distinguish it at the moment. Okay, but at the moment, yes, we'll discontinue unless there's something else we need to come back and relook at this proceedings. Okay, otherwise the proceedings is stayed pending those terms. Okay? That's that. Okay, we can open our next lecture topic. Very simple in a way. only on case management and okay, pretty simple. Active case management. If you have looked at the handout at all, then you see it's just a lot of forms and summons and conference. So when we say active case management, actually it's a bit of a misnomer here because there are many tools for the court to actively manage the case, right? This is some of those paperwork in a way, or standard hearings and conferences towards or closer to the trial. The first one, well, what are we looking at? Okay, since the CJR, the courts are expected to take a more active role in case management to further the underlying objectives under Order 1, capital A. Okay, that's all these underlying objectives and the ways and the tools and the duties of the court. Okay, we've looked at some of them. They actively manage the case. They can consolidate case. They can order trials to be tried together, and so on. One such tool would be the Timetabling Questionnaire, a sample of which is in your manual. So what it does is it has to be filed by each party. Normally during a civil case, it may be filed more than one time. It's like a progress report. It's like a progress report. The template is in Practice Direction 5.2. Okay. So it's like a progress report telling the court or reporting to the court how is what stage the case is at. Do we need a lot more interlocutory applications? Have witness statements been filed? Do you need expert evidence? Okay. And also it should include a background, brief background of the case, etc., and issues on dispute. Okay. Parties are meant to consult each other before completing the questionnaire. It is to enable the court to tailor a timetable for trial matters. Checklists on various matters to consider, including information on estimates regarding the nature, size, complexity, and case management needs. Again, apart from those that I've mentioned, it also includes, do you think there's any further amendment to pleadings, need for expert evidence, any intended interlocutory applications. Okay. Also, are there any directions you are proposing the court to make? That's proposed directions by a party. Okay, you have a standard form. Okay, filed by whoever. Which party are you? Have you, see the first thing they ask you, have you considered ADR? Okay, have you filed a mediation certificate under or pursuant to Practice Direction 31? Are there additional parties that you still intend to bring into the action? Remember, multiple defendants possible, so have you brought everybody in? Do you intend to make any more applications? Pleadings, any amendment to pleadings? Any request for FMBP? Remember what FMBP is, right? It's further and better particulars to pleadings. Evidence. Have you filed list of documents pursuant to Order 24 discovery? I confirm I do not intend to. How many witnesses are you estimating to be for your trial for your side or in support of your evidence? Have you filed and exchanged witness statements? Do you require expert evidence? How many, if you require expert evidence, how many experts are you saying? Right, in personal injury cases, maybe you need more than one, right? Issues on expert evidence. Would it be by joint expert, single joint expert, or would each party have their own? That's still E. Or E is all about evidence. Interlocutory applications. Do you have any outstanding applications that you have made but not heard? Right, because you file a summons, you need the hearing date. Right, perhaps your substantive hearing hasn't come up yet. How about, do you need any further interrogatories? In any intended application on security for costs or any other overall outstanding interlocutory applications. Case management conference and pretrial review. I confirm whether you think it's time for case management conference or pretrial review. Now, while there are two types of case management hearings. Actually, three. I lied. Okay, so there is case management. I'm going to be lazy. Case management summons. It's on your notes. Okay, it's on your notes. Case management conference. And there's something called the pretrial review. It's just they are on different pages, that's all. Okay, all three of these have to do with managing the case. Case management summons, remember this is singular. If it's summonses, it's the plural. Okay, case management summons is slightly less formal. It can happen multiple times. Sometimes it's only on paper, meaning there's a summons, but the directions can be dealt with on paper, and the court, the hearing thinking, no, not necessary, unless the party dispute on the directions proposed. Case management conference and pretrial review is closer to the trial. Now, case management conference and pretrial review, they are what we call milestone dates. So they are more fixed and firm and solemn, okay? Closer to the trial. Pretrial review, normally there will only be one, okay? Mostly, case management conference also one, but sometimes there can be more than one. The pretrial review, very rarely more than once. Okay, normally it happens maybe 2 months before the trial, the actual trial. Okay, very final matters. Okay. Because even at the case management conference, you would already start to decide on the language for the trial, estimation for length of trial, and so on and so on. Okay, pretrial review is really for any still minor details to be ironed out, so that to make sure it's absolutely ready. Okay. Pretrial review normally is it would be heard by the trial judge. Because the trial judge knows what he wants, the arrangements at the trial. So that's the difference between case management summons, case management conference, and pretrial review. Now, why would they say I do not ask for a case management conference? It's because it's maybe still too early too early a stage during the litigation. Are we ready for trial? Okay. Set the case down for trial means start to fix the date. Is it going to be a relatively short trial, or do you think it's going to last for 10 or 15 days or more than 15 days? Has there been a judge assigned? Why is this not scrolling properly? Okay, has there been a master or judge assigned on a certain matter. Running list normally goes on for PI cases or specialist list. Do you need a bilingual judge? Well, perhaps the trial is going to be conducted in English, meaning the parties' representatives would be speaking in English and making submissions in English. But it can be, you may need a bilingual judge because perhaps some of your witnesses can only speak in Punti or Cantonese. Right, so then you would need a bilingual judge. Otherwise, you would need interpreters. Preferred language for trial. If you have litigants in person and they are local Chinese, most likely the trial will be conducted in Punti or Chinese, okay, as in Cantonese. The earliest date I believe I can be ready for trial is give an estimation if it's still too early. Any proposed directions? Declaration. And normally at the back of, no, not this one, but attached to this timetabling questionnaire, you would have a one-page description on the case background and also probably another page on proposed directions. Okay. Factual background, I should say, disputes, what you define as a disputes, whether it's factual or legal, and then the proposed directions. Yeah. So that's what we do. Mediation, we already told you in pre-action considerations that all parties should consider mediation as an ADR, as an option for ADR. They must consider the possibility of settlement by mediation pursuant to Practice Direction 31. And in order to prove that they have considered it, you file a mediation certificate if all the parties are legally represented. The court will not force the parties to mediate because it should be a willing exercise. If the parties agree to mediate, they can apply for a stay of the whole or any part of the proceedings to give them the time for mediation. Okay. Now, although the heading is Case Management Conference, let's look at Case Management Summons, the less formal one first. Okay, the lighter one. At various stages of civil litigation, parties may need to seek directions on further conduct of the case. So it's from time to time. That's why it can happen multiple times. For case management summons, if the parties can agree on the proposed directions and timetable in general, then the parties can procure an order by way of consent summons in relation to those proposed directions and a timetable for pre-trial review and trial. Then there is no need for an oral hearing. Means it can be disposed of or dealt with on paper. Okay, and they don't have to attend court. Still under CMS, case management summons, if the parties cannot agree on the directions and timetable, the plaintiff must issue a case management summons under Order 25, Rule 1, subsection 1, capital B. Both parties will set out their respective proposals in the questionnaire, and the court will consider at the hearing the appropriate directions and timetable. So if they cannot agree on proposed directions, then they have to attend court at an hearing. Now moving on to case management conference. The court is to give directions on pre-trial conduct of the action. So this takes place when we progress along and get closer to the trial. Court is to give directions on pre-trial conduct of the action and will fix a timetable for pre-trial steps. Court will look at all facets, okay, have regard to the questionnaires filed and the various needs of the case. Court may give such case management directions with or without a hearing. Okay, so it can be dealt with, but normally there is a hearing when you get to the stage of case management conference. If the court give case management directions and fix the timetable for the steps to be taken pre-trial without a hearing, it's like what we call a nisi order or order nisi. So the order will become final after 14 days unless a party applies for a variation of the order. Okay, so what we mean here is the court will give a provisional. It's like a provisional order. That provisional order, which we normally call order nisi, N-I-S-I, right? Order nisi will become absolute or final. It will become concrete from the 14 days of the original order nisi. Okay? Automatically, it will become concrete or final unless one of the parties apply for a variation of those directions. If a party applies for variation of the order, the court will hear the case management summons. The court can still order a case management conference, CMC, if the action is procedurally complicated and issues are likely to arise. If the court fixes a date for CMC, case management conference, each party has to file and serve a listing questionnaire. Okay, what we were looking at in your course manual is a template of the timetabling questionnaire. What's the difference with the listing questionnaire? It focuses more on the trial itself. Okay, we call it a listing questionnaire because the case is set or the case is expected to be ready for listing or setting down for trial. It's going to get listed for a date or dates. Okay. If there is a CMC, a case management conference, the plaintiff has to lodge a CMC bundle, which would contain the pleadings, as in the SOC, the defense, and the reply, the witness statements of both parties, expert reports, and a draft index of the bundle. Okay, draft index, so sometimes when you actually get to trial, your trial bundle may include more than just the pleadings, witness statements, and expert reports, right? You may have other correspondences, you may have previous affirmations that you think are relevant. So that's why you may have a draft index indicating what are the documents. Okay, those you have to contain, the bundle has to contain the pleadings, witness statements, and expert reports, copies of them, right? But it would also have the draft index of the bundle because there may be other documents that you are still intending to insert for trial. At the CMC, the court will review the steps taken by the parties in the case preparation, fix a timetable for any future steps that still needs to be sorted out before the trial. Ensure that all admissions and agreements that can be reached between the parties on matters in issue and the conduct of the claim are made and recorded. Sometimes, during one of this, either a CMC or pre-trial review, there may be further matters that, in terms of the description of the factual disputes or legal disputes, the court will ask you or will question you, okay, about what about this point? Are you guys still disputing on that factual issue? I saw from both of your witness statements that you seem to be already in agreement at this stage. So, that factual dispute, in that case, the counsel or the solicitor, whichever the case, may concede as in may compromise and agree, yes, I think that is not a dispute anymore. We both have come to agreement on that. Perhaps because of documents review, you see that, okay, it's in with plain documentary evidence. I can't fight that anymore, so I will concede. So sometimes there are things that happen along the way, which originally may be a factual dispute or legal dispute. Now along the way, some of those issues might get compromised or conceded, okay, or dropped. Ascertain the parties' attempts or intentions to undergo mediation. Okay, are they still going to consider ADR? Or adjourn the case management conference to another date, or fix a date for pre-trial review or trial date or trial period if the master thinks or judge thinks it is ready. okay, ready for trial, then perhaps our next step is a pre-trial review. CMCs can be held by a master or judge. A trial judge is not bound by orders of other case management hearings by another judge, because ultimately the trial judge will decide how to take the proceedings, okay, or the procedure or arrangements. So not bound by orders of other case management. So sometimes you hear in the proposed directions, or you would see, unless otherwise ordered by the trial judge, the two cases are going to be tried together one after another, and the evidence will be admissible amongst themselves. Let's say that there are two cases going to be heard together. So they normally include the qualification, unless otherwise ordered by the trial judge, because they want to still leave the discretion to the trial judge, the final discretion. Okay. Okay, milestone date. They mean just that. They mean these dates are fixed by the court and intended to be firm, so it's fixed in stone. Milestone dates under Order 25, which is case management, all about case management. Order 25, Rule 1, capital B, subsection 8. Dates fixed for case management conference, pre-trial review, trial date or trial dates or trial period are milestone dates. It's very difficult to ask the court to change those. There must be exceptional circumstances to request a change to the milestone dates. You have to have very strong grounds or sufficient grounds. Now, coming up to pre-trial review, the last step. Okay, that's the last interlocutory hearing before the trial. Okay, at a pre-trial review, the court will fix the starting date for the trial if a trial period has been fixed. Confirm or vary estimated length of the trial. The counsel or the solicitor, if it's district court or lands tribunal, the judge will actually would really scrutinize the time or the estimated time of the trial. Because even before pre-trial review, you would have estimated how many hours you need for your opening address, your evidence in chief, cross-examination of the three witnesses, etc., etc. You would have given a very detailed estimate of the time, broken down into sections and witnesses, and both parties have to do it. Sometimes at pre-trial review, if the judge thinks, or even at the CMC, if the judge thinks, no, you do not need 8 hours to cross-examine one witness. You're only asking him about very simple area or very limited scope. The judge may ask you to reconsider and work around it that way. Okay, so the judge may give any further directions in relation to the trial. Pre-trial review normally takes place 2 to 3 months or 8 to 12 weeks prior to the commencement of trial. It's usually by the trial judge. Okay, one more. Construct a flow chart. Outlining the litigation milestone. So now you have to draw me the flow chart from the very beginning. Okay, tell me every bit along the way. Okay, construct a flow chart outlining the litigation milestones, beginning with the service of the writ of summons and statement of claim through to the deemed close of pleadings. Now, instead of turning to page 90-odd page, why don't I just ask you? Now, this is, well, we're not on our last lecture yet, but apart from pre-action considerations, which we're not going to go through anymore, apart from doing your assignment, you're going to show me, right? So let's assume it's a writ action. Tell me, where do we start again? What's the first document we have? We try not to look at the manual. Okay, I'm just going to go across that way because otherwise I don't think we have enough. Writ of summons, right? What else? And then what's the next thing that has to be filed? Doesn't matter by which party. Okay, time runs. Okay, so next, filing of the writ of summons. Oh my goodness. Yes, thank you. Okay, I'm just going to be lazy and just write acknowledgement of service. And then, let's forget about those Order 14 stuff first, okay? AS and then? What? Yes. Defense, if there's a counterclaim, and then? Reply. So all this is pleadings, right? Pleading stage, and then what must happen after close of pleadings? Order 24. Discovery. Okay. Okay, pleading stage close, although this is not pleadings, right? So let's say our SOC, right? Writ of summons and SOC. Okay, so we have discovery. Cannot spell. And then, what do you normally have to prepare? No ambush, no surprises. Assuming we forget all those interlocutory about security for cause, Order 14, let's ignore those. We don't have default judgments. The case goes on. Okay, so discovery, after discovery, you have no ambushes, no surprises. You disclose documents. What do you next prepare? Apart from, what's the next stage you have to do? Order 38? No, let's forget about settlement offers. What must happen? Yes, mediation certificate, timetabling questionnaire along the way. What do you need for evidence? Witness statements. I'm going to be lazy again. And then we have all those case management stuff, right? But this must all happen. Commencement of action, well, AS, and then you have pleading stage. Oops. Your SOC, after your SOC, your defense, all this pleading stage closed, discovery, witness statements. Anything else? And then all your case management stuff, right, that we've looked at today. Whether it's CMS, CMC. Actually, the first CMS can happen very soon after discovery. Okay, also, after you do your discovery, you can actually have your first CMS. Okay, but after the closer to the trial, let's say you have trial here, you would have PTR, pre-trial review, working backwards. You'll probably somewhere along the line have a CMC, right? Those are at least, those would be essential, you can't go without. Okay, you might have tried to make an Order 14 application along the way, but failed, so it goes on. There might have been some SO, SPs, and other offers or mediation. If that fails, the case goes on, but these are the essentials at least. Anything else I've missed, do you think? Right? These are at least mandatory, what we call, right? Mandatory stages. And then of course, after trial, what we are going to look at next lecture is about trial and beyond, so enforcement as well, enforcement issues. But at least up to the trial, this is what happens, sort of. Right, you can check now on the, I think it's page 94, 95, if I missed anything that is mandatory stage. That represents a mandatory stage. That's 90, 94, 95, reaction, service. Okay, I haven't really gone into the details of service, otherwise we can't fit it on the board. Discovery, TTQ. Not every case would have expert reports, but every case would have witness statements. Okay. KCMC, PTR, okay? Appeals, depending if anybody aggrieved, any party aggrieved will go on appeal, right? And then you have enforcements. Any questions? No? Then, as usual, I'll stay back for a while, but that's all I have to share with you today.